Good
Yes.
afternoon, friends. Welcome to RIPA program and this webinar after our regional conference. So, long time. Of course, our regional conference is always opportunity to meet personally. And I request all the RIPA member always to be there in our annual regional conclave as such. After that, this is the webinar because we thought that real estate is honestly a very complex topic for any IP. The one who has done, one who has not done. Every time people get scared whether to take a real estate as a IP or not, because there are many issues, and we listen a lot about decided cases and what kind of hassles all IPs face in real estate. So we thought that let's have we have our own members very well experienced in real estate. Why not to use their knowledge and experience and guide all our existing members and non-members, but our professional colleagues, IPs, that what care they should take care while they do real estate, how they should navigate, and what care should be taken. And that's why then we thought of having panel discussion so that we can take the benefit of different people knowledge and experience rather than one person talking and make it interesting. And so we have with us our own three members, Mr. Hemant Mehta, as mentioned in our flyer. Mr. Hemant Mehta is partner with APMH and Associate LLP and practicing CA, and he is veteran IP since starting 1819. We have with us Mr. Jayesh Sanghrajka, co-founder at In.Corp Advisory Service Private Limited. He is also IP and chartered accountant, and he is with real estate industry attached as IP. The same way with Hemant Bhai. We have with us Mr. Devendra Umrao, a practicing advocate and partner Mehta & Mehta Insolvency and Restructuring LLP. He is a practicing advocate and practicing IP, and he is also associated with real estate, various cases as IP. So RIPA being a non-profit organization, society registry, having presence all over India, always endeavor to share the knowledge and share the experience. Knowledge is one part, and again experience. If any IP need any help or any clarification or understanding or any query practically, this platform is such a wonderful platform where you will get immediate help. You can call anywhere, anyone, and each one will connect with you to help. And that is the real DNA of RIPA. I tell every non-member that what is the, I will say, DNA of RIPA? Help others. You ask any member anything, what I should charge, what I should take care. They will go out of way at night in the 10 also. If they are busy, they will call you at 10:30 in the night also and guide you. And that is the beauty of RIPA on each and every member. And I thank all the members of RIPA for being such a supportive to each other. Let's keep it. We are just professional colleague, but we are always first the professional friend, which are ready to help each other. That is the beauty of RIPA. And I request all other our member to be member and share the knowledge. I thanks Hemant Bhai, Rajendra Bhai, and Devendra Bhai for their time. And without wasting much time, I will request them to start to coordinate and to work out how we have organized this. Is Hemant Bhai first will talk on the real estate, IPs, how they have to manage. Then Devendra Bhai is taking decided cases, and Mr. Jayesh Bhai is taking on interim finance, which is very interesting topic in real estate. And then there will be certain questions I will ask, time permits, and we will allow participants to ask the question afterwards. This is the modus operandi. In between, however, if anyone wants to ask, put a question in the chat box or any suggestion. With this, I'll request Hemant Bhai to start his presentation and his talk. Thank you.
Thank you, Dipti ma'am, for your kind words of introduction. I will just put my slide on the
Yeah.
Can you see the entire screen, right?
Yeah.
Fine. So at the outset, I thank you all the RIPA members and thank you Dipti ma'am for inviting me for this topic, which is to my heart because I have been working in the real estate sector since I have started working as an insolvency professional. And with this, these are certain disclaimer which I would like to share before making my presentation, which are standard. So with this, I will just introduce briefly, about myself. That is, I'm past president of and founder member of RIPA. Worked as an IRP, RP liquidator, AR, home buyers, AR of home buyers, then AR of financial creditors, resolution applicant, monitoring agency, valuer, transaction auditor, and statutory auditors for companies under IBC. Possibly all the roles which has been envisaged for a professional under the IBC regime. And in real estate sector, I have been directly or indirectly involved in more than 10 real estate resolution cases as IRP, RP, AR, process advisor, preparation of resolution plans for real estate plans, companies, and as a monitoring agency. So this is briefly about myself. With the real estate sector, I would like to, give certain key statistics about the sector. As everyone knows, the real estate and construction sector is a very crucial sector, and it constitutes about, the real estate sector are cumulatively the second largest contributor, with 33% of the CRPs being admitted against the corporate data. Engaged in the said sector, recoveries is about 20% of total recoveries under the IBC. If we will see the history of IBC, total there are about 1,000 cases which has been already resolved, out of which about 3 lakh crore rupees has been recovered. So real estate sector has also done a wonderful job in recoveries as well as in resolving the cases. So there are approximately 4.12 stress dwelling real estate units with investment to the tune of 4.08 lakhs crores in the said units. Further estimation that if 75% of the said stress units are resolved, it will add another 3 lakhs units to the housing sector. The resolution of these stress units will not only provide the much needed respite to the entrenched LOTs, but also significantly contribute towards the economic growth of the country. And this statement and statistics has been derived from the basically a report of the committee from the Ministry of Housing and Urban Affairs on legacy stalled real estate projects. So these are the statistics about the real estate sector. Friends, there are very few, I can say how normal cases, because all of you are insolvency professional. So I will not take any basic things about the insolvency, but I will like to differentiate the insolvency of the real estate cases vis-a-vis the other cases, where either you are handling some manufacturing company, or you are handling the case of some trading company, or you are handling case of some other sector company, manufacturing or trading, or it may be some logistic company like that. So how it is different, to manage, and how it is different from the other regular CARPs. So let me tell you that so these are the points where I can differentiate the real estate sector from the other normal sector. Like home buyers, as you know, the home buyer has been given a special status after the JP case, and even after pioneer case. So that has been given a special status as a financial creditors. Here the special regulators are coming into picture, like RERA, to handle the companies and there are in the RERA also we are by handling the cases of home buyers, we come to complaint from the home buyers like that, that you have given me lesser area, or you have charged me extra than the RERA. So you need to resolve those kind of queries from the home buyer also. And sometimes few home buyers are of very, when they are taking possessions, And if you are handling as an insolvency professional, the same case, there they are even complaining, there is a water leakage from my flat, or these are this kind of complaint you just receive day in and day out. So, this kind of things which are you have to face as an RP for real estate sector. There are varieties of stakeholders under the land, like landlords. In one of our cases, the landlord is consisting of 6 or 7 families of the same, cousin brothers, and totally about 37% has signed the, development agreement. So now to resolve the case, I need to obtain consent of all the 37 members. Once I get consent, then only one can resolve this case. So it's very difficult or very tough, to get the signature of all the people under the stress assets where there is hardly any recovery, and you tell them that I will not be in a position to give you the area which you have already, enter into the development agreement. You will have to compromise with the lesser area. So likewise, this call has to be taken, and you need to, be very careful about the handling all these peoples. Even in the, SRA or MAHADA or DDA, you have to, these are the basically properties or plots which are being, owned by this kind of authorities, government authorities. So if the friends who are joining from out of Bombay, slum rehabilitation authorities are there in Bombay. I don't know about the other cities, but there is a slum rehabilitation act as well as slum rehabilitation authorities where, there are slums, and then you have to get the slum place vacated. You have to rehabilitate with the new building or new structure at the, given as per the government rules, and then you can be permitted to construct the buildings for commercial purpose or for the sale purpose. Okay. So these SRA authorities are also authorities which can challenge your project. In one of our case, the project at the car is still lying under the SRA authorities, and we are challenging the orders of SRS. So likewise, the MAHADA in Maharashtra, DDA authority, that is Delhi Development Authorities, in Delhi area, collector. Even some of the societies are having about, say, 20 years legacy. They are also holding certain plots or certain extra areas which is to be developed. So group of landlords, as we have already discussed, and likewise, so these kind of stakeholders are there where you have to be very careful, and you have to, adhere to the law of that particular authorities like SRA or MAHADA or EDA. You cannot say IBC is supreme, because no doubt certain areas where the, provision of the laws are equal, or the provision of the laws are, similar to those of IBC. In that case, IBC can be supreme, but otherwise, at other areas, you cannot say, you have to adhere to those laws. So also, about stakeholder are having their own regulations to comply, and, variety of demand to resolve the case. So, we have already discussed that. Then for successful resolution applicant, challenge is even if you are, you have the successful resolution plan with you, and there is a successful resolution applicant, he has to also face the challenges like post permission of various authorities. In one of our case at Kandivali, the environmental authority had, taken about 1+1.5 year to give the NOC for, revalidation of the approvals which was granted 10 years back. So these kind of challenges which we are regularly facing, like approval of revised plan, revival of permissions like environment department, aviation department, restriction of height on the area when the airport is nearby. So all these kind of challenges has to be, you have to fight. This is not probably, I can say this is not there in the other industry. This kind of challenges are not there. There are also challenges like encroachment by local leaders. So slum level dwellers, landlords after, after the sale. So, you have to just practically take the order of the court, take the help of the police, and still we are not aware, we in one of our case, even after obtaining the order from the court and obtaining the permission from the, NCLT order, we have already given it to police station. Still, we could not be in a position to get the land vacated, because of the local political forces and all these things. So these kind of challenges are there under the real estate cases. The land bank with various challenges like restricted use, reservation for special class of people, landlords, possession after sale, etc. So the challenge is like restricted use. In one of our cases, we have the restricted use that particular place can be used for the salt pan only. So now in that case, how to come out of those salt pan restriction? Whether I will be in a position to sell the land for any other use or not, or it has to be sold as a salt pan, and then subsequently the RA can take the call to convert the use from one to another. So these are the kind of special, I can say, features of the real estate cases. The legal challenges like Section 14 violation. If registration of home buyers flats are done, see, there is I think I have heard of the one cases where the RP has taken an objection that if he is going to, registering the home buyer's claim or a home buyer's flat, which are there available as in stock in trade, so there is it is a violation of Section 14 for such home buyers during CRP period. How many of you do you agree whether there is a violation or not? Can you give me some idea? Anyone?
Can you repeat the question? What it is?
See, if I execute the document, see, as per Section 14, I cannot, I cannot fight any legal case, or I cannot execute any document for the properties which are in the favor of, which are going against or on, the CD as such, in the interest of the CD. So whether if I am already handling a case, of a builder where there is some stock in trade, and if I am executing the document which are not being executed, and if I will execute the registration and sale deed, I will be in a position to realize something from receivables. Okay. So whether can we say that is a violation of the Section 14 or not? That is what my question is.
Yeah, participants, anyone? All
Raviji.
hands are there.
So this is just for the, because I just want the participation to be, active in the in this forum, so that I'm just.
Rekha ji.
May I speak?
Yeah, sir.
Yes, sir.
Yeah. To answer this question or to answer it for ourselves, let's slightly change the question and come to a manufacturing industry
Hmm.
where you are producing, let us say, just for the sake of, we will say cars. Okay.
Hmm.
And somebody has paid you full advance for the car. Right?
Hmm.
And during CRP, it's a going concern running. Can you deliver the car?
Yes, exactly same.
Yes.
Exactly.
Yes.
So anything in the normal course of business, Section 14 does not apply. Stock in trade, though it is immovable property, is not immovable property for the developer.
Rightly said by Raviji, and rightly, responded by Dipti ji. Any other view in the matter? Fine. So, that is the, peculiarity of this real estate industry or real estate sector, where, basically this is our stock in trade, and we can definitely Even in my cases, when I handed over in the cases in the first month of itself, I got an order from NCLT allowing me to register the documents of the home buyer and handling over the possession, to the home buyers. And if the sale deed is to be executed, I have to execute the sale deed and take all the due diligence which I have to take. So this is how we can deal with this situation here. Then even the completion of incomplete project during CRP over the possession, and handling over the possession to the home buyers after formation of societies and procuring the occupation certificate. So this kind of orders has been given to me during the one of the cases which I am handling, and the project was not completed. It was about out of 9 floors, only about 5 floors were completed, and other stakeholder was there who was ready to complete the project, and he agreed to complete, and I was representing CD in the 50% of the stakeholder in the capacity of that. So in that case, I procured the order from the I missed the other stakeholder has procured the order from the NCLT and ordered me to see that the project is completed, all the due diligence about the home buyers, and the entire you are being given a task to become a builder, literally. So like that, the order was there, and then we could be in a position to complete. I will show you the picture of that particular project, before and after completion at the end of this slide.
Sir, in
Yes, sir.
JP Infra case also,
Yeah.
while the CIFP process was on, large number of flats were completed and handed over, and even registry was done.
Yes, sir.
Now,
Yes,
of course, it is under monitoring committee. Now they are handed over to Sanghrajka also. Yeah.
Right. So, NCLT and if as an RP, if you come across such kind of situation, you can always seek the help of NCLT order or to decide about the matter. And if they direct, you can complete the job. So,
can I say something, Hemant bhai, on this?
Yes, sir.
Sorry, whether NCLT we should approach proactively, or we can do the registration if the COC consents for registration of the documents, whether we can do it or not. Is there any thought of anybody here? Because approaching NCLT, filing petition for registration purposes, is it required if COC approves it? That is the only thing which comes to my mind.
That answered the earlier question which I already asked. But anyhow, any members are welcome to give their views. So let the members give the answer.
Can do it.
I am of you. Though
I have a question.
Jayesh, I have done it actually with COC's permission because I hold a similar view that it is.
I have a question now.
Right, sir. You can ask the question.
Shivaraman here, sir. First of all, good evening
Yeah.
to all, everybody over there.
Good evening. Yes.
First thing is, for example, there are 100 flats.
Yeah.
And 50 flats are completed by the builder previously. 50
Right.
are to be completed by the RP.
Right.
Now, registry can happen only until the whole project is completed, or is it, what to say, for example, you have to get the water connection, sewage plant treatment, all these things have to be completed. Before that, the registry cannot happen. This is my point of view.
Right. Absolutely correct.
Right.
Absolutely correct.
Now, for example, if such a situation arises that the home buyers force you to, for example, in some of the cases where it is half completed and a full payment has been received and people are asking for registration to happen, how do we handle such cases?
So in that case, as per RERA, we cannot execute, we cannot just see registration of document is concerned. I think, the possession is the restriction over there. What you are telling now, occupation certificate, after obtaining occupation certificate only, you can part with the possession. Registration can be done after certain point of time when during the construction also, that is what I am under impression. Any other member can definitely give their views, please.
I have raised my hand.
Yeah, Sanjay ji, please. Sanjay ji.
Yeah, so I think there are numerous case laws as well as I think there was a discussion paper. I'm not sure whether the regulation has been amended, but all flats, irrespective of whether they were already ready prior to CRP or they are getting ready during CRP, can be sold, registered purely because they come under stock in trade of a company as a going concern. It is not alienating the assets, but it is sale of the stock in trade, and hence it does not come under. In fact, it does not even, while it is beneficial to take COC resolutions, but frankly, once the RP is in charge of the operations, while he can take a COC approval and that's good enough, but even if, let's say in the worst case scenario that he doesn't even take, but he would still not be foul of, operating the sale as a operating the company as a going concern, because he's selling something which is part of the company's business and it is stock in trade. So sale of and registration of flats, including giving possession, occupancy, etc., is all part of the real estate's, business, and he's only running that. So that's my view. I am open to being corrected.
Ravi ji, your view, please.
Yeah, I more or less endorse what Sanjeev has said with one slight difference. Okay, and that's because of the peculiar nature of the product that is being actually sold here.
Right.
The invariably, I mean, majority of cases, the flat would be having a charge of the financial creditor on it. Okay.
Right.
And that needs to go away once you are giving registration and possession. And which is not the case with movables, because hypothecation doesn't create specific charge. It's like a floating charge. So there is no restriction on
Ravi, what there's a home loan from that person?
No, not home loan. I'm not talking from the buyer's loan. Okay, that's different. That's between him and his lender. Okay, I'm talking of where the project developer has created a charge by taking a loan, project loan. Okay. So that loan has to go away, or that charge has to go away when transferred. And that can only be done by consent. It's not automatic. And that's where you will get into this problem of some people who don't understand it, talking of Section 14. And then one-to-one, you have to explain to them, that, sorry, boss, this doesn't apply here. You might have a charge because it's immovable property. It could, if it was movable, what would you do? Would you, if you are selling washing machines, would you come in the way? No, this is same. Think it is a washing machine. Okay. So then
Like
you
a
have
stock
to.
in trade.
So, so this is the peculiarity in real estate, that the consent of that specific lender for removal of charge will be an additional requirement while giving possession. They can't say no. That is when you might have to go to NCLT or somebody. But you know how people are, so they will not understand it and they might say no.
What is our experience of panelists? Whether
I agree with Ravi bhai, because the point is this, that every bank will have a charge and they specify sometimes a unit number also, sometimes a flat number also.
right.
Now, if that particular flat is in the mortgage list, mortgage deed, they may specify the number also. I have faced a similar situation in Radius matter, but we did not register any document. Subsequently, the matter NCLAT has decided. The point is this, that during the CRP process, when there is a charge already of a particular lender, whether we can do a registration without NOC, that's the reason I was of the view that we should take a COC consent. COC voting power of more than 66% is my view, and maybe the bank who has charged it may not give the consent, but if all other agree, because it is a common pool according to me, and we should be able to register it. That is the view I think we can take. But if we don't want to take risk, then we can go for specific direction from NCLT.
Jayesh, I largely agree with you, but with one difference that COC's powers are subject to, and I mean their power of what do you call, you know, taking everybody around, or let's say enforcing the will of the COC on everything is limited to common issues. It, strictly speaking, cannot go to specific issues. So one lender has a charge on one unit. Without that consent, it cannot be, but they cannot hold the consent if their payment itself has been satisfied, in the sense that the buyer has made full payment. So no buyer can be made to suffer because of something which the lender has an issue. So in case that particular person or institution says no, that is when one might have to go to NCLT and take a direction. Most of the time they will not say if you explain to them, but समझने में थोड़ा time जरूर लगेगा.
Right. So I think Jayesh, by your question has been answered by all the distinguished members of RIPA who are present here, and they all are very senior, and they are all having experience of not only working as an RP but in the stage assets also. So anyhow, let us move to the next slide. That is as regard to the withdrawal by successful RS during approval stage or thereafter. I have seen the number of cases during the approval stage withdrawal, but in real estate specifically, I have not come across any situation where the RA has withdrawn after being allotted as a real estate plan. Here, there are many members who might be aware about those things in the real estate sector I am talking specifically. So have anyone experienced or have anyone have the idea about any plan of real estate company which has been withdrawn after approval of the plan by NCLT? That is my question.
There is one thing which has happened with regard to this Prabhojit Singh Sodhi case. Probably there will be more number of resolution applicants who will be withdrawing the application because of the demands by the landholding authorities. Because they have been treated as secured creditor, we have to wait and watch. With regard to this, because the resolution applicant is forced to make the full payment, because landowning authorities don't even give 1 paisa, naya paisa down for making the claim. They want everything in full. Even during CIRP also, they say that it's a continuing cost which you have to pay and make the payment. So it will be a difficult task for any home buyer, for any resolution applicant to make this payment. Of course, if he has deep pockets, then that is different story. But normally we have been treating the landowning authority as operational creditors up till now, before Prabhojit Singh Sodhi's case. And we have been allocating funds as an operational creditor with the thinking that there will be some directions from NCLT to handle this, to help us out in getting the registration and other things to be done. But this is something which is going to happen in the near future.
Yeah, in even one of the project also, there are the problems which are right now created, as I have learned from from some authority, that they are creating a problem, and it is likely that new RA may withdraw the plan, but it is not still withdrawn, but it is under dispute, but it is on that stage of withdrawal. So therefore, I just took this point. No doubt, this is a common point which is applicable for all the type of resolution cases, whether it is manufacturing or trading. But still, in real estate, we have heard very rarely about this kind of situation. But anyhow, this may come in even real estate cases also. So similar is the situation with 29A violation in few cases. I can say all of us may be agreed, few cases or more cases, I don't know really. But directly or indirectly, in certain cases, the promoters either promoter's influential company or promoter's friends company or promoter's relative companies might have taken the, role as the resolution applicant, successful resolution applicant. And on the back door of it, promoter might have run, the show. But anyhow, we are not just indulging into, detail about this thing. Now let's move to the next slide. So, there are key government initiative to boost to the, basically to real estate sector, infrastructure sectors. So, here, anyone has any idea about Gati Shakti infrastructure? Or for that matter, Swami. So basically, let me just touch upon these points. Gati Shakti is infrastructure sector, a government of India national infrastructure pipeline initiative to provide a platform for the transparent online information on the infrastructure project and services required, including information about the state's infrastructure projects. I have already visited the website today itself only, and I have seen there are 3573 states assets which are under the infrastructure sector, and they are available, and they are available for even sale also. So these are the assets which are there listed on the website. One can go and see. So there is a very good website. I think Gati Shakti is the initiative taken by Prime Minister Modi in every sector. It is not only in infrastructure, but if you will type Gati Shakti in Google, on various sectors, the Gati Shakti website has been created and given all the possible information about the national level projects and other state level projects as well. So it is very good site, and one can go and just see. And if any one of the client is interested in taking over the state's assets, they can definitely go and visit that assets, and they are putting a red, again the name, they are putting a red mark as if it is a state assets like that, So they are giving all the details about the project, where it is going, what is, for example, infrastructure project, then, road construction project, how many kilometers of road, they have taken the tender, and everything is available on that website. It is a very good website. Since we are covering the real estate as well as infra, which is related sector, I thought that let me try to, explore this particular slide also. So Swami is a fund which is by SBI Venture to fund the state's assets delivery. Then they have delivered about 23,000 plus houses and unlocked the liquidity worth of 35,879 crores. And the target is to give 1.1 lakhs unit in tier 1 and tier 2 cities, or about 30 cities they have already worked with. So normal mode of funding is issuing the NCDs. And basically, the first project which was completed successfully was a Revali Park project at Borivali in Mumbai by Swami. And I think majority of IPs might be knowing about it. So the RAs, whenever they come, we normally ask them whether you are being financed by, or you have any proposal of financing from some from tie-up. What is your tie-up for financing? So some people say that we may approach the Swami fund for
Very common for real estate.
Yeah. So this is how it is being funded. So this is just for the information of the members.
Thank you, Hemant bhai. This is helpful to others and other participants also very much. Thanks a lot for your effort.
Yeah. Thank you. So, now I can say new cases of, there has been many cases in the NCLT, but because of this real estate sector, what kind of concept has been, prompted the court to think about and prompted to give the order in peculiarity cases of the real estate. I will not go into much detail, but if required, member can raise the question and then I will go into detail. But special status of home buyer, as you know, everybody, in JP case, and the special status has been allotted thereafter to the home buyers, as in financial creditors, then reverse CRP, then project-wise CRP, then cases pending with, official liquidator. They were brought back to resolve by CARP under IBC. Then special permissions to home buyers who have already occupied the home to keep those units out of CRP, under out of CRP and execute the sale deed. This has been now an amendment, their amendment were proposed on this ground, and thereafter, this all the, I think majority of the things has been brought in, or they have been brought in, or they are proposed to be brought in by way of amendment in the regulation or under the IBC regime, and they are being covered nowadays. So these are the peculiar situation which also, made the code for having the innovative idea to introduce all these things and then to, resolve the cases specifically for real estate. So, yes, sir.
Hemant bhai, two things. What information needs, I'm an AR in one or two cases, so what information needs to be given for home buyers? Because home buyers demand all information which is required. Basically, the COC matters and other things and the voting pattern you have to share. They ask for too many information. Now the NCLT, their petition has been filed, they want a copy of the petition also. So what technically you are supposed to give?
I don't think, basically, normally as an AR, we are doing the job of representing the case before the COC, and whatever can be shared with the COC members, that area only we have to share it with.
Yeah,
So
I agree
you
with
have
that,
to
but
decide as an
lots of lawyers'
RP
notices
what
have
you are
come.
supposed to give to the COC member or what you are supposed to share with the COC member. The same thing can be shared with the home buyer. So that is the general rule. You can definitely, any other members can, discuss this point. Yes, Raviji, please.
In one of the cases.
Yeah, Devendra.
Yeah, in one of the cases, one of the home buyers is a lawyer. So he has filed a case in NCLT. So he demanded the petition copy and other things. So the representative has given it to me. Now he's telling me to give it to everybody, which is not technically right.
Yes, sir.
My view on this is very simple. Actually, the allottees are the members of the COC, except that they don't physically come there. They vote by giving a mandate to the AR. The AR doesn't have an independent role at all in terms of formulating any opinion on a voting issue.
Right.
So he's just like a lawyer for his client. He can't, use his own judgment on what to say or what not to say if it is contrary to the client's mandate.
Raviji, what the matter
So
is?
1 second.
Yes, sir.
Yeah, you want to say speak. Otherwise, let me finish.
Yes, sir, speak up, then I'll speak.
Yeah. So every document which a regular financial creditor as member of the COC is eligible to receive, all such documents, even the allottees are eligible to receive. There cannot be any other interpretation of it. You can't treat them as second-class FCs. They are on the same table at par. Just that the voting is done in a different manner because of the numbers involved. That's a practical issue. Remember this, if the number of allottees is less than 10, what happens? There is no AR.
Right.
Okay, so AR, the process of having an AR and the procedure is only a practical way out because of the numbers involved. It is not a change in law or a change of the rights of parties. The rights of parties are the same, whether you are an allottee or you are a bank. If a bank can get X number of documents of this type, the allottee also has to be given the same. There cannot be a different law.
Very clear.
The judgments might be against it. That doesn't mean judgments are right. Let us also remember that every 3 years, at least 3 to 4 Supreme Court judgments get overturned by the Supreme Court itself. Okay, because they realize with passage of time that something was wrong. We are all human. Okay, judges are not gods. So just because there is one judgment which is by chance, maybe the facts of the case are different. The issue is there or something else. It could be. So we cannot come to a conclusion that it is always a precedent for everything. First is logic, then is law.
I'll connect with you privately with
Yeah.
Hemant Bhai and you both.
Yeah.
Yeah.
Yeah. So now let us move ahead. Special permission to restart the project told. Since more than say about 10 years or 15 years, where the court is of the view, and if some home buyers, group of home buyers or society or any home buyers association approach, the court can give. So they have already been, in past also, in one of my case only, they have given the permission to restart the project, complete the project, and execute the sale deed and registration. So all this can happen only in real estate cases, Then ordering the acceptance of cash. Now, who thought that cash, any transaction involving 10 lakhs, 15 lakh rupees cash, that may be also be accepted by the court, because it was the part of the executed document prior to CRP period and registered document. So therefore, court has accepted in one of the cases, I don't remember the citation of this case, but they have accepted that since it is already mentioned in the agreement that the gentleman has paid the cash of say about 10 lakhs or 15 rupees, and it has been acknowledged by the CD, it has to be accepted. So this kind of situation also has been already tackled by the NCLT, and they have given the favorable order in favor of the buyers.
Hemant bhai, I would like to only add that in one of my earlier case of Aristo, there was some cash receipt. Ravi bhai is aware. And because of that cash receipt, some chittis were there, but we did not allow. And because it was not part of allotment letter also, and it was not part of agreement. I think it bases the facts of the cases. If it is mentioned in the document which is registered, you have to accept. Otherwise, I think you cannot accept. This is my.
The moment you accept the home buyer's claim, all the claimant will come that I have paid 10 lakhs rupees by check and 10 lakh rupees by cash. So how will you accommodate the cash? So we don't entertain at all. We said whatever is written under the written document and it has been come through check, that is we can accept. But here is a peculiar situation where it has been already written on the document. So therefore the court has there. Otherwise, normal cases, case transactions are obvious, and they had been, rejected day in and day out by the RPs over the claim, on the claims part.
Hemant bhai, in that particular case, I had read that order. So
Yes.
there were certain peculiar facts which were very specific to that. And one question was asked, do you have proof that it was never received? And the RP could not justify that, probably because of passage of time. But the default one is very clear. If the books of the corporate debtor do not reflect that receipt, it doesn't matter whether it is paid in check or cash. It has to be reflected in the books. And additional evidence by way of the bank. Even if you are received in cash, तो आप खाएंगे तो नहीं. You will have to put it into the bank. It has to go there. If that is there, then yes, then cash by itself is not a hurdle for admitting a claim.
Yeah.
We all know where the cash goes. Cash never goes into the bank account anyway.
Right.
Why would anybody pay cash? This is not agriculture produce. Okay.
So even the letters which were specifying the cash has been paid, we have come to across the situation where the promoter, after being admitted in CRP, can issue any kind of letter, backdated letter, to the allottees or. So they had come out with the letter stating that this much amount had been, the promoter is acknowledging this amount has been paid. This is the receipt of the same, and you have to, this 10 lakh rupees which is written as cash, you have to accept. So we have to verify the books of accounts. If it is not deposited or not accounted in the books of account, we never accepted it. So, this kind of situation is also arising. I have the hand raised from the Manish Jaju. Manish ji, tell me.
Sir, I have one simple issue. Like Jayesh bhai told in Aristo matter, or Ravi bhai told that there should be in books of accounts, those entries. So let us assume that there is an agreement, there is a cash receipt shown in the agreement, and there are multiple type of transactions of the same nature, like they had in Aristo, chittis. So do they form part of a PUFE transaction? Because these are the transactions they commonly enter into before CRP period. Or should home buyer himself go to the authority NCLT and ask them, okay, these are the fraudulent nature of transaction, and therefore, or RP should go ahead and file a fraudulent application, okay, these are the motives of modus operandi followed by the promoters. They were taking cash, they were issuing receipts, of if they are taking amount of 1 crore, they say okay, we have accepted 1 lakh rupees. So this type of receipts they issue, these are the common type of transaction. Or in Aristometer, they issued just one one small chitti saying if they are accepting 1 crore, they say 100 rupees accepted. So do such transaction form a part of PUFE transaction? Or should RP go ahead and file a PUFE? These are the modus operandi followed by promoters prior to his coming into as an RP.
See, PUFE transaction is one where there is an inflow and there is a illegal outflow.
Yeah.
If there is no inflow shown in the books, there is no PUFE. That's a criminality of a different nature, where somebody from the corporate debtor side has defrauded some buyer and taken it out without giving any document, not entered into books. So if the inflow is not in the books, it is not within the jurisdiction of the RP to do anything about it, because that's in personam issue. Yes, the allottee has knowingly or with, should know common sense, has given cash and not bothered to take it there. So unki baat hai. See, why does do pay in cash? To avoid stamp duty, right? Or to
avoid stamp duty. In our case,
their own source of income doesn't justify buying that much value. These are the two. So they are anyway breaking the law. You can't side with lawbreakers.
So not only stamp duty, there are 4 types of reasons for this. One is not obtaining NOC from the lender. Then the other is the GST payment. And the other is there is an agreement with the land developer that they will pay 30% of the revenue. So to avoid such type of revenue payment to the landowner, they enter into such type of transactions.
Yeah,
there are 3-4 reasons why
they are for breaking either a contract or law. You can't side with such.
Yeah. Right, fine, no problem. So that was an issue. That's all. Thank you.
Yeah. So friends, let us go ahead because I am now eating on the other people's time also. So I will have to run quickly. Anyhow, so we have already seen the acceptance of cash consideration of duly executed sales did prior to CRP period. That also has been accepted by court in this peculiar situation as discussed. Thereafter, recommendation of special batches for real estate cases. It has been a long demand, and I think government has also announced once or twice. So we may face see the special batches for real estate cases for that matter. See, this is the one of the project at Kandivali where we have prepared the resolution plan, represented the RA, and successfully completed the job. And it has faced an environmental issue for more than 1.5 years. This is a project where we have completed the construction. You can see the incomplete construction and completed construction. The first picture is about incomplete construction, and the second one is completed construction, which was completed during CRP period. And then, handed over the possession from the society, obtained the occupation certificate, and this is that project. And this is the project, the same project which was already shown earlier slide, where, there has been a board by the local politician, stopping the work of our construction site. And thereafter, we have approached the politician and then, threaten him that, the election is coming and better you be out of this because this is a court matter. And you don't have to, if you will interfere, then you may face the court issues. So that he has taken immediately this board out of the site, and then we could complete the construction at that point of time. This was during COVID period. So friends, I think few cases, as you know, that in JP case, additional cost towards construction was charged. So these are some of the instances how the matter of real estate are settled in past. I am just giving few instances. There may be other methods also. But in my knowledge, these are the methods which has been, the real estate project has been settled. Like in JP, the additional cost toward the construction was being charged to the home buyers, and the home buyers have agreed to that, and then the projects were completed. In Orbit also, additional cost of old home buyers 3,000 to 5,000 per square feet were charged, and the new home buyers to new home buyers, cut-off cost of rupees 15,000 per square feet charge, less rate originally booked. So like that, this particular case has been settled in Aristo Private Limited. These are the orders which, basically majority of them are the public domain. So I'm disclosing this thing. Old booking, lump sum amount, extra charge of 3,300 per floor, plus floor rise charge towards the construction. New booking of 2015 onwards allotted the same rate. So, it's all upon the timing difference, old booking, new booking and all that. In my opinion, new booking and old booking, I think the rate of 8%, which is the time value of money, that is already been discounted in the matter. So normally, I don't know why people are offering into such a, such a situation, old and new rate, because that interest factor itself is taking care of the timing difference. But anyhow, this is how the case was been resolved by offering this kind of settlement to the home buyers. In Metallica, the actual cost of construction was recovered from the home buyers, and in SRA projects, slum levels were recognized as per the SRA rules. So these are the kind of settlement which has taken place among the home buyers and the new resolution applicant, and this is how it has been settled. Now, I have not seen anywhere, the area which has been compromised. Now, for example, if a home buyer has booked 1,000 square feet of home, and now new resolution applicants say, no, I will not give you 1,000, but with the same rate, I will give you 500 square feet. So this kind of, settlement were proposed in a few of the cases, but I could not see the, that whether it is resolved or not. So anybody has any idea about any other mode of settlement or any other way of settlement which has taken place between home buyers and successful resolution applicant?
So I will like to add, in Modela case, there is a full refund to home buyers because they were 15-20 years back. We had only suggested this when we made the plan. I was not the RP there, that you refund a total amount to the home buyers, because the project was 15-20 years back, and the configuration of the flat size and all that was not viable to make at that particular site. So that Modela case can be referred. The other thing is area difference. Suppose you revise the planning by RA wants to revise the plan from 2 BHK to 3 BHK or something, same size 2 BHK, but there will be 5-10% variation. Those type of things has happened in Ornate case also, where you can specify that 5%, 10% variation in the area will be there because of the plan changes. So that type of thing has also happened in Aristo also. So that court recognizes, and otherwise it is not possible to give the exact area also. So that's, and there was a change in definition of RERA carpet and all type of other things was also there prior to RERA and if the projects were started. So those type of so those type of variations are possible to build in the resolution plan.
The delay penalty which builder has to give, that is waived by the house buyers up to a particular date in JP Infra resolution case.
So fine, friend. I think a few of the cases where I think, but here I would like to add one thing, one more point. I like to ask the audience one point. Whether have you seen any homebuyer case which has gone to liquidation? I have not seen. I have not come across any such kind of cases. But some of you might have come. I don't know whether any homebuyer's case has gone to liquidation and how it was been settled. Any idea about it?
So I will just add, it is not happened as of today, but we are facing a situation where the timelines are over and home buyers are not agreeing. There is a financial creditor and home buyers are not agreeing on any resolution. So I feel that it might go in liquidation. That is what is my feeling. So far, it has not happened in my this. But today there was a COC. There is a stallment. So I think there is a possibility of liquidation in a particular case which we are handling. But I doubt it will happen. And there is a problem. Why there is a problem? Because there was a joint ownership of the land. Land was owned by somebody else. Development right was with the CD. And that landowner is not cooperating. and there are landowner says, I don't want any resolution, let the company go in liquidation, and he is not part of the COC also. So that issue is there, and there the FC wants a solution, but RA wants the consent of the landowner also. That in that situation, the matter can go into liquidation. That and it might have happened in some other cases also. I really don't know, but this is a particular problem if the landowner doesn't cooperate and RA cannot put up the plan, or RA will lay the conditions. So that situation we may have to face.
Right. Lekaji, you
And
were
also there is no Form CA in
Yeah.
liquidation. So then they'll have to file a claim in Form C and they'll be a financial creditor normal.
Right. In liquidation, what will be the status of home buyer? That is what you want to say, right? No doubt, it is already laid down in the court as a financial.
Yes,
So
yes.
one has to file the form as a financial creditor only, and he will come
Yes.
into the waterfall of 53 as the unsecured creditors. That is what I think.
Whether RERA can be
Devendra
concealed.
bhai,
Yeah.
I think you have not opened your the judgment page actually. You are still on the index. We can see. on
Acha,
the-
I can see on my screen judgment enclave principal bench. Has it not moved? Is
No.
it showing?
No, you have to share the screen. That screen has not been shared.
Devendra bhai, you have actually shared your desktop. So you will have to move out of that and share your presentation file.
Yeah, so that's what I did. You are screen
No,
sharing.
you have to open. No, just come out of the share mode. Stop sharing first.
Okay.
Open the file now. Open the file now.
Open the file now. Okay. Yeah, is it?
And now share the presentation file.
Can you see it now?
No.
No.
Just 1 minute. No, I have to go to share screen, right? That's what I did.
Yeah, there is an icon, no? Arrow.
Yeah, that's what I did. Then I went to.
So you will be able to. No, we are still able to see your desktop only.
Yeah, so here I went to the relevant file and opened it actually. That's what I did.
But stop sharing first. Go there. Open the file.
So like
Now I think
is it
abhi bhi
visible?
dikhega वैसे. No, it is opening, I guess.
Devendra, you have to stop sharing first, open the file, then start sharing.
Okay, I'll just do
That
it.
is the sequence. Okay.
Just
Open the file on your laptop. See that it is open fully. Then click on share screen.
Is it visible now?
Yeah.
It's come.
Okay.
Needed
So
screen.
it's visible now?
Yeah, visible, but just
Yes, yes.
You can see it now?
नीचे क्लिक करना होगा आपको प्लस के बाजू में साइन है ना वो उधर
No, I have moved to slide 3 actually.
No, make it full screen.
फुल स्क्रीन के लिए वो नीचे है ना राइट हैंड साइड में बॉटम में
And left hand side में जो
Dipti, hold on. वैसे नहीं होता. Dipti.
हाँ.
The only way to see it properly is go to slideshow. So there is a tab called slideshow right at the top. Slideshow.
हाँ, स्लाइड शो ऊपर है ना देवेंद्र जी ऊपर है.
Yeah, right.
Slideshow. New
No,
name. One second, hold on. सब लोग slideshow.
Just 1 minute, sir.
अभी
आपको ऊपर सबसे टॉप में देवेंद्र भाई सबसे टॉप में आपको एक मिनट ना दीप्ति ऊपर टॉप में आपको 4-5 आइकॉन दिख रहे हैं. एक उंगली का आइकॉन दिख रहा है.
Sir, you can just
उसके पहले एक
he is going to the wrong one.
उंगली का हाँ ये वाला हाँ एग्जैक्टली इसको प्रेस करिए.
You can see it now?
Yes. Done.
Okay. I'm sorry for this delay.
No, it's okay.
So the first order that I'm taking up, I was talking about is the one about this is RERA versus DB Corp Limited. This order was pronounced by NCLAT Principal Bench on December 8, 2023. So I was talking about the main two issues which were there in this matter. They were basically, in my understanding, whether RERA can be an aggrieved party. Does it have a locus, to file cases in such matters in IBC? And another was obviously at the core of the entire dispute, wherein the operational creditor based on which this matter was admitted into insolvency process, whether it at all was an operational debt. So these were the two main issues. So this is a matter of Messrs. AG8 Ventures Limited. This is a real estate company in Madhya Pradesh. So basically they entered into agreements with DB Corp Limited. Basically, the idea was that while AG8 Ventures was a builder, you can say, and DB Corp would provide extensive media coverage, by various means, newspapers and all other means. And the agreement they supposedly entered with each other, that is the corporate debtor and this company DB Corp, was a barter come cash payment agreement. So in lieu of providing publicity to AG8 Ventures, DB was to be paid by way of cash and check, as well as by way of allotment of residential or commercial units in the respective ventures of this corporate debtor. So what happened in this case is that this petition was admitted, the company was admitted into CIRP. And after that, this RERA filed this matter saying, obviously alleging that this was a collusive matter and this cannot be treated as a operational debt also, because the only payment in this matter which was left was the cash component was already paid, they said, and only the units which were to be allotted were left behind. So they cannot be called as operational debt. So obviously, I mean, the respondents went against this holding of RERA, and they said that RERA, first of all, has no locus. And secondly, obviously, they justified that since units were promised and they were not delivered, and this was against providing the service of publication or publicity for the corporate debtor, then it is operational debt. So NCLAT considered these matters in detail, and the arguments by RERA are given here. They obviously said that Section 9 application filed by DB Corp Limited was invalid because it was not a genuine operational debt. Obviously, they talked about collusion between CD and operational creditor. And they said that they do not meet the criteria of this. The respondent said that the respondent was DB Corp, that is the operational creditor. He said that the amount was very much due, and obviously the debt was very much an operational debt. And it was a legitimate debt that was owed, and they refuted the allegation of collusion. So the NCLAT came to the conclusion that, first of all, in their opinion, because RERA already had passed orders in this matter. In fact, RERA had passed various, a slew of orders in various projects of this company. So they said that since they were already an involved party, so they are an aggrieved party under the definition of Section 61. This was the first thing. So they have the locus to file this application. And secondly, they concluded that since this barter agreement supposedly had two components, cash and allotment of units in lieu of the services, cash component has already been paid and only the barter portion is left. So they said this barter does not fit into the definition of payment, because for any claim, a payment has to be due. That is, they said has to be payment of money. So allotment of units in lieu of services cannot be called payment of money. Hence, in their opinion, this cannot become an operational debt, and hence they obviously cancelled this impugned order, saying that, I mean, the CIRP was obviously withdrawn in this case. because they said that this debt is not an operational debt. So two things I thought it impacts real estate matters. One, that in future, obviously, RERA can be an aggrieved party and they can, have locus in such matters. And secondly, a little bit about what an operational debt is, whether agreements of barter will form part of, such debt at all. So this was my first selection for this case. The second one is Pankaj Mehta versus Messrs. Ansal High Tech Township Limited. Here also the judgment is pronounced by the principal bench and CLAT. Now in this case, broadly the matter is that basically this township, this is in our neighborhood. I stay in Noida and it is in the same district. So this is a very large, township project. So this consists of multiple projects. It's not like there is a 5-acre or 10-acre land and there is one project. So this being a large, I think it's more than 100, 200 acres, and it has multiple projects within its, boundaries. So in this, as you can read here, if you can, that basically they purchased flats in the year 2011 and 12. And obviously the builder was to give them possession within 36 to 40 months. So but the crux of the matter here is all this is normal in real estate cases, allotment and then promise of possession after some time. But here what has happened is that these multiple projects people got together basically to file a Section 7 application. So what came for NCLAT's, consideration was whether they can, group together to form the new definition after it was altered, that it should be at least 10% of people from a project or at least 100, allottees have to come together to file a Section 7 application. So that was the main issue which came for consideration of NCLAT. I think I have put the issues here, whether the various projects within the township should be considered as separate real estate project or as part of a single real estate project, and allegations by the respondent that the main insolvency petition was filed with a mischievous endeavor by some applicants to extract money. So this can be ignored. So the appellants, that is, appellants for this high-tech city township real project, they argued that they should be put together because it is part of one mega township. The respondent obviously said, which in my opinion also is a valid argument, that these projects were separately registered with Real Estate Regulatory Authority and had approved sanctioned plans relating to the respective projects. So obviously they would have different timelines, different, sizes, different amenities in each project. So respondents claimed to be financially sound, and obviously they pleaded other things like due to some COVID issue and all, they had issues. But the main contention was that each project was separately registered with RERA and had approved separate sanction plans relating to respective projects. So the NCLT's conclusion was they dismissed the application filed by the appellant and other petitioners under Section 7 of the Insolvency and Bankruptcy Code. NCLT considered the multiple RERA registrations submitted by the respondent for different projects within the township and found that the applicants do not meet the threshold limit of 10% or 100 persons for any specific project category. So the conclusion is that basically if the project is registered separately in RERA, then the condition has to be met independently. You cannot club separate projects and then come together, 5 people from here, 10 or 15 from a different project, and then you club, even if the builder is the same. The conclusion, in my opinion, is that for this condition to be met for filing Section 7 application, it has to be met independently in each of the projects. I think we'll read it here. So, NCLAT upheld NCLT decision and mentioned that appellant and other petitioners did not establish themselves as creditors of a class concerning any particular project registered with RERA. The NCLT referred to the definition of a lottee and real estate project. So basically in support of their decision. The third judgment, in fact, I was a part of this case, is Vishal Chelani and others versus Debashish Nanda. I am an authorized representative in this matter. So this matter pertains to Buland Buildtech Private Limited, and I am fully aware that frankly, even I held the view that it is correct. So in this case, what had happened is that, like in all cases, it has happened in my other cases also, that some of the home buyers approach RERA and then they obtain orders from them for a refund of the money with interest from a certain date. So what the RP had done is that whoever had this kind of order, they were asked to file Form C because they said that your amount has already been crystallized. You asked for a refund. So this comes under the definition of, financial debt, and you are a financial creditor. You file Form C, while of course the other allottees who were who were natural home buyers, including these were also home buyers, but they had not approached RERA and they were still waiting for their flats. So they were obviously asked to file Form CA. So this contention was also upheld by the NCLT bench where the matter was going on, because obviously these people first went to NCLT. It was bench 2 in Delhi. And NCLT held that yes, the distinction created by RP is valid since RERA has given an order of refund with interest. So it becomes a financial debt separately in the form of Form C, while the home buyers who are still waiting for their flats, they will file Form CA. So this also the matter went to, finally this reached up to Supreme Court. So it was, in fact, it was held by NCLAT also that the distinction is valid, but Supreme Court, did not hold a similar view. You can see the argument that this is the resolution professionals argument that the appellants, by approaching UP RERA and securing specific amount, should be treated as unsecured creditors, unlike other home buyers who had not invoked remedies under the Real Estate Regulation and Development Act. They contended that allowing the appellants to secure two benefits would be inequitable and that the appellants fell into a different subclass of home buyers due to their actions before UP RERA. The resolution professional emphasized the distinction between home buyers who had opted for remedies under RERA and those who had not. NCLAT ruled that the resolution professional's proposal to treat appellants differently from other home buyers did not warrant interference. So basically, NCLT as well as NCLAT agreed with RP's view that since their amount has been crystallized, refund has been ordered with interest, they will form part of Form C financial creditors, unlike other home buyers who are part of Form CA. However, when the matter went to Supreme Court, they overturned this decision, declaring that the appellants as financial creditors within the meaning of the IBC and are entitled to be treated as such along with other home buyers. According to the Supreme Court, the distinction that the resolution professional created was inequitable, and in fact, they said that it violates Article 14. So the judgment highlighted that the underlying claim of an aggrieved party crystallized in the form of a court order or decree. So this has finally become the guideline. Earlier, in fact, there were some high court decisions which also supported what RP had held the view. However, after this judgment by Supreme Court, this last line has become the guiding principle, that underlying claim of an aggrieved party crystallized in the form of a court order or decree does not alter the status of the concerned party. Here it is written as financial creditors. Basically, what they meant was that the original nature of the transaction will not be altered just because they have gone to RERA and they have managed to get refund orders or something. So they allowed the appeal in favor of the appellants, that is these home buyers. Now they have been, the resolution plan and addendum was filed and their treatment was changed subsequently because the Supreme Court order came recently. I think this came in March 2024 only.
Sir, only one point, if I can add. Sorry.
No, please.
suppose there is a refund order and some
Yeah.
part refund has been given,
Yeah.
then what is the situation?
So in my opinion, though no refund was given, as usual, normally builders keep fighting this. But if it would have been given, probably it will be adjusted in the claim. This is what I can think loudly, that, when you file your claim, you will find it with that reduced amount.
But it will be home buyer.
It will be home buyer. Yeah. So the last line, that's what I said. I'll go back to this.
Underline.
That the original nature of the transaction. So this has become the guiding principle now in all cases, that original nature of the transaction will not change. So if your original nature was of an operational creditor, you have obtained a decree, you will remain an operational creditor. And if it was of a home buyer and you approached RERA and got a decree, you will remain a home buyer. That's what Supreme Court says. So we have to go by it now.
Sir, but the letter has been exchanged prior to CRP date. The partial amount has been refunded. The CD has agreed to give certain amount of interest, percentage of interest in the writing format, and then also how can it be treated, because partial amount has been already repaid. The person don't want the home at all. So what to do?
See, if you ask me, I will agree with your view. As I said, I was part of this matter. I'm still as an authorized representative. And similar transactions have come up in my other cases also. And though luckily this matter didn't come up, the cases are now resolved. But I held the same view which you are saying, that since you have opted for refund, your nature of claim is different. However, what was happening in some cases, that because, why these people went up to Supreme Court, because the treatment obviously of the FC and the home buyers was different. Because the home buyers were getting their homes, so they saw that they are getting, benefit, the prices have increased now. While as financial creditor in the plan, they were taking haircuts, so normally a resolution applicant will pay 50% of their dues or something. So that is why they felt aggrieved and went up to there. So I also held similar view, which you are expressing. We thought it is a crystallized financial debt now. You asked for refund, so you are a financial creditor. But now Supreme Court's decision has come, so I have, we have to abide by that. That's what I'm saying.
Yeah, sir. But only one point. This was because of UP RERA order, and there was a UP order. But there is, suppose, no UP. They have not approached UP order, any RERA authorities, and they have decided to claim the refund, and the builder has agreed also. What happens if there is no order or a decree? In that situation, what happens?
Jayesh, I would say that in that case, because this agreement to surrender the flat and take refund has already happened. So then they will definitely come in Form C. Because, yeah, so that situation is totally different, because it has been agreed upon, agreement is crystallized, flat is surrender, and refund has been, agreed to and given also, you are saying, partly even. So that definitely should remain in Form C. If I were in that place, this is how I will,
So because there are two situations. One is this surrender agreement, whereby without going to any authority, there is a mutual agreement. There are sometimes buyback agreements also, and that agreements also they sign, and then during the buyback period, if the CRP starts, no payment has been made or part payment has been made, those should be financial creditor, I suppose. There is no order or a decree underlying.
Yeah, there is no order or decree, and there is already a agreement. So I think that agreement will prevail over the BBA.
Because my similar situation has happened in one case in Noida, so that's the reason I'm. It's in Gurgaon, not Noida.
Okay, okay. Yeah. So I would say that the subsequent agreement takes precedence. This order is would then be restricted to the matter of decrees in decrees or orders of statutory authorities, in my opinion.
Because there is a similar situation in barter system also. I don't know how do we, barter. If there is a barter agreement and there is a dispute in the court, and there is the court decides that okay, this allotment should be given to this operating creditor, and underlying document is in nature of barter only. But there is a consent term filed in the court. In that situation, even a barter agreement should be treated as a home buyer only. No?
Yeah, it should be.
Because underlying document is a decree, court order, consent.
Yeah. Yes.
This is where some matters it is happening because there is an operational creditor who disputes with the developer, and then developer he goes to operating creditor goes to court, and there is a consent term. Then in that situation, even barter will be treated as a home buyer.
It will be, in fact, in the first case that I quoted, I was in a hurry to conclude it in time, so I didn't mention. In fact, the same DB Corp which had filed the case as operational creditor, because that was also a barter, they had also approached the RERA. So the court took note of that you have approached RERA as a home buyer, kind of. So now you cannot suddenly become an operational creditor. So, I mean, in a way, it is linked to what you are saying, where such thing, and they happen. Even I have seen some suppliers, getting flats in lieu of their payment, in builder cases, because they are short of money. So they say, up flat lay low, or whatever commercial unit lay low. So it happens. So moving on to the next case, this is
in case the refund amount has already been refunded in a particular case by surrendering the allotment, then no claim will survive. If it has already been done before insolvency commencement, claim has to be as on the insolvency commencement date.
It has to be.
Yeah, then no claim is there. He can't file claim in any capacity because he doesn't have any claim thereafter.
You are right, Indraji. Jayesh was talking about part refund when he first began.
Yeah, part refund, of course, will result in the remaining part coming as a claim. But in case if it has been fully refunded and the flat allotment has been surrendered, one of the instances was that.
Yes.
So if the allotment is surrendered, amount fully is refunded back to the allottee, then no claim survives.
Then no claim survives. You are right.
Thank you, sir.
Yeah. Thank you. Thank you, Indraji. So moving on to the next case, this is a case of Mr. Ankur Narang and others versus Mr. Nilesh Sharma. This judgment was pronounced by NCLAT Principal Bench. Here the facts were that this was again a large project in Delhi NCR area. And here, in fact, the total claims were in the range of about, in fact, it's written here. So there were about 1,500 home buyers and total claims ranged in about 1,110 crores. Out of these, about 25 home buyers, after the approval of resolution plan by the COC, went in appeal against the plan. I mean, they had objection about their treatment. Now, again, these people, the cases are almost, I mean, the facts are almost similar to what we were just discussing. So basically they had, I mean, the issue is, the decision is on a separate matter, but I'm just telling you the issue. So basically they, their flats, they were asking for refund of their flats. And in the resolution plan, also their treatment was given that refund would be given, but it will be given only after the sale of respective unit. So they had gone in appeal saying that, they have been treated differently because we had asked for refund. We are treated differently from other home buyers who are getting their flats, and we are suffering because of that. So that was not the issue. The issue was whether being 25, which is written here, that which is a wafer thin minuscule minority, can at all, raise such an issue, because financial creditors in class are taken as a category and they vote as a category. So NCLAT said that merely because there is a reduction in the claim of any creditor, it does not make the resolution plan illegal. Any clause in the resolution plan that requires creditors to take a haircut cannot be construed as being violative of Section 32E of the IBC. Further, it highlighted, so basically these guys, when they went, they said that, the justice has not been done to us. So NCLAT analyzed that they were given an opportunity to meet the resolution applicant. RP had given them an opportunity to highlight their issues to the AR. So it was done transparently that what treatment would be given to their claims. So they said a fair opportunity was given. But the conclusion was that, again and again in this decision, Anclat quoted JP matter and quoted Supreme Court's, extracts, wherein it said that basically the minority will have to sail with majority. So since the resolution plan was passed with 96.3%, so they said that your grievance in this will not have, any change in the situation. As a class, the plan has been approved, so you cannot raise these objections now. So basically what I am highlighting is the crux was whether a minority within a class can raise objection. So this was conclusively denied by NCLAT, saying the collective decision, as in the way the voting is done, will prevail. And as long as you were given a fair opportunity within the process, whatever the process allowed, approaching the AR, RP, resolution applicant, that has been given. There is no case of, treating you any differently. Whatever the plan says and howsoever it treats your claim is different. In fact, they also raised the matter of the previous decision that I discussed about the decree holders, being treated differently. So NCLAT said that we've gone through that judgment also, and the facts of that case were different, because there the RP had asked them to file a claim as in Form C as financial creditor. Here you were already filing claims in Form CA, and you were part of the same home buyer set. So your facts do not match with that, and there is no application of that case here. Now, that was the decision of NCLAT. Moving on to the last case, this is very important. In fact, I had a practical insight into this in one of my cases. So this is a recent Supreme Court judgment. Basically, the issue here is of counting of votes. So I would like to tell you that the issue involved was that how the counting of votes is done. Now, all of us here, Hemant Bhai, Jayesh, everybody, deals with real estate cases, and a lot of participants must also be knowing about it. So you are aware that, the majority vote share is counted, and then the entire voting percentage, which is allotted to that class, is treated to have gone, with the majority. So let's say if home buyers have a 60% share as financial creditors in a class, in a COC, and only 30% vote, but even if in that vote the majority votes in favor or against a particular resolution, so it is treated as the entire 60%. So this issue came up that if this a matter of withdrawal under section 12A comes, then how the voting will be counted. So as you can see here in the second para, the issue was whether the vote should be counted as per section 25A 3A, as in JP Kensington, where this rule was laid, where more than 50% voting in favor results in the entire class being counted as in favor, or as per the more stringent proviso to section 25A 3A, read with section 25A 3. So I can't screen share this, but just for your benefit, these sections obviously are already there. And section 25 3A clearly reads, I am reading from a printout actually, that notwithstanding anything contrary contained in subsection 3, the authorized representative under subsection 6A of section 21. So 6A of section 21 only defines financial creditor in class, shall cast his vote on behalf of all the financial creditors he represents. This we are aware of, right? Now, in this itself, in 25.3, it is clearly written, 25.3, that the authorized representative shall not act against the interest of financial creditor he represents, provided if authorized representative represents several financial creditors, then he shall cast his vote in respect of each financial creditor. Please mark these words. In respect of each financial creditor in accordance with instructions received from each financial creditor to the extent of his voting share. So this was the issue, that whether the majority vote will count, or this 25A3 will apply in case of section 20, in case of 12A withdrawal. So NCLT ruled that for a proposal under section 12A to withdraw a CIRP, individual votes of the allottees must be counted as per section 25A3 and not collectively as a class. So just note the difference between section 25A3 and section 25A3A. So section 25A3A talks about voting as a class. The matter went to Supreme Court and the NCLAT decision was challenged, but ultimately upheld by the Supreme Court, which confirmed the distinct voting mechanism for approving a resolution plan and separate mechanism for withdrawing CIRP under section 12A. In fact, in one of my cases, the COC, they were basically part of the COC, secured financial creditors, were having a meeting with the promoter, and they called me to join that meeting. I was asked to come. I think they started meeting maybe at 4 o'clock. I was asked to come at 6 o'clock. And they were discussing a withdrawal proposal. And when I went and explained to them this, they said, oh, we have wasted 2 hours, because they knew that getting 90% votes under this mechanism from home buyers will be a challenge, because each vote will be counted, and normally home buyers have shares like 0.10 and 0.15 and all that. So they dropped this proposal. So I hope I have been able to clarify the distinction between voting in normal cases, in case of financial creditors in a class, and voting only for withdrawal under section 12A. So this rule applies of each vote, each share, each voting share, only in case of withdrawal. In all other cases, the majority vote counts rule will prevail. So this was the last case for me. We are already, in fact, approaching 6. So if any clarification regarding this, or else we can take up at the end of the session as Dipti ma'am decides. My cases are over. These were the 5 important decisions I thought I can share with you.
I think any discussion? No, I think even the question is not there. If any question, or otherwise, Jayesh will take up for Interim Finance. I think it is not there. So Devendra ji, thanks a lot.
Ma'am, I have one question.
Yeah, please.
Sir,
yes, please.
Regarding that 25 voting only, that section read that decision taken by the majority of the home buyer, that the AR has to cast vote according to that. Suppose out of 100% voting right of home buyer, 51% home buyer have casted their vote for a particular resolution. And in that 26% voting right have given for the favor, and 25% voting right are for non-favor. The vote has been casted 51% voting right. So in this particular case, the AR has to vote for the favor as in the 100%. Na?
Yes, he has to vote in favor. Okay. This is very clear. Even if in your example, I will just clarify it further. It was not 51, it was only 40 or 10. Even then, if 6 were in favor and 4 were in against, he has to cast for the entire percentage.
No, sir, but in that case, it is not by the majority. Na? It tells that
no, it is by the people voting. The whole decision, this thing was changed in case of JP only because lot of them never came to vote. So it is of those who are voting. Yes, this was to solve this issue.
Okay. Out of 100% voting right, if only 10% voting right have casted their vote and 6% have given in the favor, then also the AR
the entire class will be counted. Yes.
Okay.
Thank you.
Okay.
Thank you, ma'am.
Thank you. Jayesh, you can take over, please.
Yeah, so good evening, everybody. I learned a lot of things from both the speakers, Hemant and Devendra bhai. Lot of learnings, even after resolving so many cases. Each case is a separate case, separate type of issues arise, and separate type of decision, as Ravi bhai was also saying. every year some overturn of decisions is happening. Like barter system also, there are some cases which I am facing. Now, as regards interim finance, the topic which has been given to me, I will just only share my practical experience. Whatever I have faced or I have done in two matters. One is the Radius Estate Developers, where there was an interim finance, and one is the Ashiana matter, where again there was an interim finance. And there was this is where the initial, 2 years back, 2.5 years back, Radius matter at Bandra BKC. So our RA was Adani, one of the RA. But before resolution plan was approved, there was a condition put in the UI also that before 31st December 2022, certain amount was to be infused for payment of statutory dues. Because statutory dues are for premium purpose. If you don't pay that, then the project was becoming unviable and the cost would have increased substantially. That is the reason that condition was put by COC member also. And RA was supposed to put the that interim finance before 31st December 22. So that amount was around more than 100 crores was to be paid. And plus there was a condition that RA will infuse the fund for the construction purpose also. So these were the two basic conditions basis which the resolution plan was put to vote. So this the challenge was that if you don't do this, there was and further there was a High Court decree also, whereby the original landowner society was also supposed to be paid rent amount of more than 100 crores. Otherwise, the development agreement was getting terminated. So that's the reason the COC wanted that High Court decree should be honored by RA, and this payment of BMC statutory dues, premium charges should be paid. So this the resolution was approved, plan was approved basis basis infusion of the interim finance. That was on 27 December. Before the deadline of 31st December, which was given by both authorities, High Court also, as well as for premium purpose by BMC, for also it was there. So that we made we made interim finance agreement. We made what you call resolution plan was approved by 83%, and interim finance agreement was also approved by 83%. And that's the way this whole interim finance of 400 crore was infused. And after the approval of the plan, and within 3 days, the amount was paid to the statutory authorities and High Court, as per High Court decree, to the original flat owners of the society. So the arrears of rent was there of about 100 crores. So now this, after 31st December, even construction funding, the RA did, and RA did infuse total sum of about 700 crore before the plan was even approved by Honorable NCLT. So Honorable NCLT approved the plan after 1 year, and then it went into NCLAT for because there was secured creditors were getting only 7%. So they went into NCLAT questioning this interim finance, questioning the conduct of RP also, how we allowed this interim finance and all the documentation and all that. But ultimately, NCLAT has also upheld that interim finance agreement and interim finance infusion, all that, because there was an issue. A secured creditor had certain mortgage on certain units also. That also was an issue. They were of the view that if there is a mortgage and if you are allowing interim finance, you are in a way parting with our rights also, because there was a clause in the interim finance agreement that in the event if the plan is not approved, then this whole money, whatever is being infused, will be treated in priority as a CIRP cost. So these were the various things which had happened in this particular case of Radius. I hope everybody is following what I'm trying to say.
Yeah.
Jayesh bhai, in one of my case, where COC is holding about 80%, Now they were, releasing the payment up to only 80%. So I said, how can I run the show? I cannot pay the fees of 80% to my advocate. I cannot pay the fees of 80% to any stakeholder or other buyers also. So you please kindly, give me the full interim finance. So ultimately, home buyer and all that agreed that okay, 20% will be given by of interim finance, attracting some interest.
So this, in my particular case, as you know, radius matter. The issue here is that if interim finance of such a huge amount is, see, normal CRP cost is okay during CRP process, but interim finance for construction purpose, and that too with consent of 83% only, not 100% of the COC. So whether such type of things can be done under CRP process, and what do you make during this process? What agreements are made? Like interim finance agreement is there, or development management agreements are there, and same RA is doing all this work. Whether this type of things should be allowed or not. And fortunately, we were of the opinion that see, a business has to run. Otherwise, the project would have become unviable. High Court decision was also there. So in view of all of this, RA is COC felt that RA should infuse money, and RA also agreed, and then the resolution plan was approved. Otherwise, there was no resolution, and there were more than 700 home buyers getting impacted. So that's the and as I said, NCLT to approved the plan, and interim finance also, which was already infused to the extent of more than 400 crores till the time NCLT approved the plan. And subsequently, after 1 year, NCLT also upheld that decision. So of interim finance. So that's where what I'm trying to say is that all the project in real estate would, if we initiate interim finance and if COC agrees and some RA is ready to infuse the fund, whether such type of things should be allowed or not legally. Now this decision is in favor of such type of decision. This is what I understand.
So,
Ravi bhai, any view on this?
Jayesh bhai, I have a question. Ravi ji, I think probably
He's not there. Yeah.
Is not.
Jayesh ji, I have a practical question. So you are saying this interim finance was introduced and this was part of the resolution plan, or how did you?
So it was recorded all in the COC meeting on 27 December. Before that, there was plan came on say 14th of December. 15 days there was negotiation that there are some deadlines. If these deadlines are not met, the project itself will not be able to, because there was a High Court decree for payment of arrears of rent. Plus, there was this issue about payment of statutory dues. So COC in its wisdom, and I also supported that view, because I felt that our job is to protect the project. If the project is not there, there won't be any resolution. So that's the reason I also, and along with my legal team, took a view that yes, this should be allowed. So there was a negotiation, deliberation, and there was an interim finance agreement which was entered into, and that agreement has been that agreement was also approved along with the what you call is the plan approval. So in plan approval also, the same thing, all documents were part of the same, different resolution, but same process of CIRP. On the same day, all the resolutions were passed. Devendra bhai, because that radius decision now is in public domain, it has come 15-20 days back. So that's the way it was structured. Even NCLT and even court has upheld that RP has not done any wrong in this, because it was anyway it was for the protecting the project, and it was COC direction also was there. Without that, in any case, we will not be doing it. My larger point is this, that all this type of stalled projects, which are stalled for 10 years, 15 years, and if there is some hope of revival, and if some hope of interim finance, see, normally COC members themselves should be funding this and to start the project. But if they don't want to fund because of whatever their policy, and if RA is funding it, and RA only wants protection that in worst situation, if their plan is not approved, then their money, whatever is infused as an interim finance, should be treated as a CIRP cost, and it should be in the priority. That is what RA expects.
And there is no restriction, right, in the law that interim finance cannot be raised from this person or post. There is no express.
There is no restriction, and the preference in payment is of course embedded in the law itself.
Is there an interest portion also?
Yes.
So my generally Swami fund is there. Hemant Bhai was also referring. There are the Swami fund also had met, and in some project when CIP process was also going on, Swami fund has taken a view that I think in Saregama and some other project that during CIP process also they can fund the they can fund the incoming RA and their priority can be created on that particular loan what they give for construction funding till the plan is approved. So Swami fund most probably they do all this type of things. I don't think there are any other fund which do these things, this type of funding. So this was the case of Radius and the legal issues. All we know, challenges are there. I don't think there is much clarity on this because sometimes these are huge amount, huge project. Suppose the plan was not approved, then what would have happened? For some reason. And so there should be some clarity on this. And I was talking about, and even banks and institutions are worried about that. Swami funds, suppose funds it, and there is for some reason there is a delay in plan approval, or the matter goes up to NCLAT and Supreme Court. How long they are also going to wait? So this type of some inbuilt law protection should be there for interim finance. That is what ultimately it is COC's decision, because priority of that funding is important, because they should have the priority if there is some event of liquidation or something of that sort. So this is my view. And similar situation happened in Ashiana, which was Gurgaon project. In Ashiana developer also 15th August 2013 was 2012 was the deadline, and there was a 50 crore infusion required. Otherwise, the license was getting rejected. So license for doing that particular project, and there was a substantial increase in the liability. If the payment was made, there was some amnesty scheme going on under law of that. And that amount was to be paid before 15th of August. So plan was approved by 12/13. There were 3 plans which were received. 3 plans were considered by COC. But the basic condition in the plan was that you have to infuse so much amount before 15th of August. And by 14th, the 13th or 14th, the plan was approved. And within 1 day, they made the payment. So that was another case where some risk RA also, see, it is ultimately risk of RA because they infuse the money. If they see value in the project and COC also agrees, then this all can be done. But these are all cases where their RA needs to infuse the fund, or some institution backing RA has to allow this funding. This is the RA's credibility and COC's approval. But in the meantime, as again the question is that this plan also got approved after 1 year, and if something had gone, and during this 1 year also construction was ongoing, and construction, and that's the reason now after approval of NCLT, the matter is the buildings are almost getting completed, and occupation will be given by December. So these are, if we play some proactive role, and RA, if we are able to convince that you can infuse the fund and you can start the project, nothing like it. And for example, what happens in the reverse CIRP also, ultimately it's a money game in any project. Reverse CIRP also, developer says, okay, I am going to bring some money, I will start the construction. COC agrees, but end of the day, there has to be some funding which is required to be infused in the project. So that funding only will take the project forward and protect the project. This is where financial institutions, COC, RA all have to consider how do we introduce interim finance, and how the law protects them, that becomes critical. And not every COC member is going to be there. There will be never be 100% COC consent for interim finance. Most of the cases. Now, in my case, it was 83%. In Ashan also, it was somewhere around 80 or 83%. So, if the other creditors object on the conduct of this whole process and interim finance, that you are alienating asset and all that stuff, I'm not that legal guy, but then we also have to take a view whether what we are doing is right or wrong. But that's from me. If there is any question, we can discuss. But and other thing, today whatever we have discussed, Hemant Bhai slide was also very good. There are major issues, in the land ownership rights. I will just touch upon it. Land ownership rights where there is CD doesn't own a land and it is a landlord is there. Those type of CIP cases also, most of the cases are stuck because landlord doesn't agree. And this is a phenomena all over India. I was discussing in Bangalore one seminar also. Same thing in Bombay also. I'm handling certain matters where landlord writes how if they have a revenue sharing or area sharing, and if they don't take a haircut, the project is unviable for anybody. So then financial creditor, how do you balance? And landlord do not sit on the COC also, because they don't. They only have. They are not part of the COC. So even if you complete the project, if you complete the CIRP process, and RA puts a condition that landlord will be given, say, instead of 50%, 30%. Whether this type of plan will be approved by COC, by NCLT or not, and what happens to the landlord rights, what he was entitled was 50%. So this law, I think, will evolve ultimately. So similar situation, joint development agreement also, same situation is there. But unless there is a cooperation of all the stakeholders, I don't think things will. And even in SRA project, same issues are there. Some in one of the matter, the SRA land was owned by a private landlord, not a public. It was not a public land, and his right was getting impacted because of the resolution plan. So this situation is there everywhere, and particularly in Bombay, there are many such cases which are stuck. Anyway, this is my view. If there is anything, Dipti Ben or anybody else from the group, we can discuss.
Anyone wants to ask any questions to Jayesh Bhai, please?
Yeah, I would like to, have thoughts of Jayesh Bhai as well as the members of this group, where, the bank is having a 80% of share and they are ready to finance the 80% of the cost. However, remaining 20%, they said we will finance subject to 15% of the interest. So is it possible to give the partial amount on interest and,
Why not? I think we should allow, because interim finance, there is no restriction on payment of interest. Now, if the COC member himself is funding any particular, suppose only one COC member agrees that I will pay 100% of the CIRP cost or some incidental cost, and you pay me the X amount of interest. I think that should be allowed. In most of the cases, home buyers don't do it. Don't fund CIRP cost. In our Ashiana matter also, we had this situation where funding was done by FC and we had an interest clause.
Okay.
So this type of thing, interim finance interest, definitely whoever gives interim finance, they deserve to get interest. Otherwise, why they will fund? And if it is even a COC member, he should be getting interest.
Right, sir. Thank you.
Anyone, please? Okay, I think everyone is in Saturday evening mode. Thanks a lot, all the three panelists, Hemant Bhai, Devendra Bhai, Jayesh Bhai. Thanks a lot for your time. I was chasing Jayesh Bhai since long because of his practical experience and recent cases he handled, which is in public domain. Thanks a lot for your time at the Saturday evening. Thanks all the participants for your active participation. We'll come with another topic at the month end, set off in CRP and liquidation, and our Devarajan sir and Mr. Ganti will be there. So we'll declare the date and share the link. Please join everyone. Thank you.
Thank you, everybody.
Thank you, ma'am. Thank you, everyone. Thanks.